So I think without going too much into detail, the basic interaction takes place at what you'd call the regulation of the input or training phase of an AI model. So what you have on one hand in the Copyright Directive of 2019, the Copyright in the Digital Single Market Directive, is a set of provisions as exceptions and limitations for text and data mining. So you have an Article 3 that is aimed at research organizations and cultural heritage institutions, that is mostly aimed at text and data mining for scientific purposes. And it has a number of requirements, namely one I think we'll talk about later, which is that you have to have lawful access to the materials that you text and data mine. And on an additional provision that covers all entities, that applies to all entities and would cover also text and data mining for commercial purposes, is in Article 4. And the main difference in that Article 4 is that it's subject to additional requirements. Well, both the beneficiaries of the exception are broader, but on the other hand, you have additional requirements. And the one beyond lawful access to works that is mostly debated is that you have to allow rights reservation, or what is called opt-out, mostly for content that's publicly accessible online. So the way this works is that if you do, for example, web scraping online from a publicly available website, there would have to be a mechanism that would allow the opt-out of rights holders.